Welcome to JEG Law, a professionally acknowledged leading immigration and nationality law office in the state of Nevada. JEG Law is a comprehensive immigration and nationality law practice that is prepared to address all citizenship applications, investment-based procedures, family-based and employment-based procedures, removal defenses, asylum and related applications, and immigration-related federal litigation. Philosophically, we understand that American business and society are fed and developed and not burdened by both common sense immigration law and a deep respect for human rights. Pragmatically, JEG Law is a client-centered immigration and nationality law practice, providing our clients with unmatched personal concern. Now please enjoy this presentation as our gift to you to keep up with the ever-changing and dynamic field of immigration and nationality law. With over 22 years of experience behind us, it is our pleasure and honor to serve you. Now, I'm going to discuss President Obama's executive immigration order. It's an immigration fix. And first let me say, to begin, that only Congress can create immigration law, but the President can issue policy orders to guide how existing law is enforced. This is exactly what President Obama did by using an order on November 20th, 2014 to amend the manner in which existing immigration law will be enforced this coming 2015, while continuing to intensify border enforcement and prioritize the deportation of felons and not families. President Obama has ordered that an estimated 5 million undocumented immigrants will be granted employment authorization for a 3-year period through deferred action. You need to remember that deferred action has been in existence since the 1960s and is best understood as the selected non-enforcement of immigration enforcement provisions guided by humanitarian reasons or when in the public interest. Deferred action must be granted on a case-by-case basis, but it may also target a specific identifiable group for a case-by-case individualized determination to grant or deny this benefit. Persons granted deferred action can also apply for an employment authorization document. Recently, deferred action for childhood arrivals, also called DACA, was implemented by President Obama for unlawfully present persons who had been present in the United States on or before June 15, 2007, who arrived before reaching the age of 16, and who were under 31 years of age at the time of initial application. DACA was made available to eligible persons whether or not they were subject to removal proceedings or even a final removal order. The filing fee is $465 with no fee waivers available, and applicants must either have graduated high school or be in the process of seeking a high school diploma or the equivalent degree when applying to extend this benefit. An equivalent degree, for instance, would be a GED. DACA was initially granted for a 2-year period and has recently been extended once. The President's recent order extends the arrival date for DACA to January 1, 2010. The order removes age restrictions for the applicant, so now you can be over 31 years old at the time that you apply, and it extends each grant to a 3-year period, not just a 2-year period. Moreover, a new class has been considered for a new program entitled Deferred Action for Parental Accountability, DAPA, for individuals who are parents to U.S. citizens or lawful permanent residents who arrived in the United States prior to January 1 and who pass background checks demonstrating that they are not an enforcement priority. The President's recent order also acknowledged the contributions of high-skilled immigrant workers, exceptional ability workers, and entrepreneurial immigrants to our nation's economy, explaining a variety of administrative reforms that would be implemented by regulation no later than 180 days following the President's policy order issued on November 20th, 2014. The President thereby acknowledges our nation's need to retain the most talented students educated within American universities and thereby maintain the competitive advantage of our economy. Likewise, the President has also ordered both deferred action programs be implemented by regulation no later than 180 days following the November 20, 2014 announcement, and this means on or before May 19, 2015. The President's executive order has been further explained by numerous memoranda issued by the Secretary of Homeland Security, Jeh Johnson, among others. Having reviewed these memos, I provide the following explanation to itemize and explain each of the President's directives. This explanation may not address every question the reader may have, as certain terms are yet to be explained by the Obama administration. Additional and ongoing research will no doubt become necessary. So feel free to rely upon what follows in order to understand the many criteria used by the Obama administration in processing these newly created immigration benefits. Individuals will be covered under a new program, Deferred Action for Parental Accountability, or DAPA, with the following conditions. They must register with the U.S. Citizen and Immigration Services and pay taxes. Of course, most of them already do. And they must be parents of U.S. citizens or lawful permanent residents born prior to November 20, 2014. They must have lived in the United States on or before January 10, 2014. They must have been physically present on November 20th, 2014, and at the time of application for deferred action. They must lack lawful status as of November 20th, 2014. They must not be an enforcement priority, and they must present no other negative factors which would make a grant of deferred action inappropriate. 2 points that need further clarification and will rely on regulations deal with what is a parent of a U.S. citizen or permanent resident. The order has to, in my opinion, rely upon the definitions created in the Immigration Nationality Act, which in this case rely on the definition of child. Well, that's logical. But in immigration law, under the Immigration Act, a child is defined many ways. A child, an orphan, an adopted child, a child born out of wedlock, a stepchild. And the stepchild is the issue that seems to most concern my clients because the beneficiary says, that's not my child. But under the Immigration Act, a stepchild is a child. So I'd be very surprised if the regulations come out and discredit beneficiaries who are step-parents of U.S. citizens and permanent residents. But we'll see about that. Now, deferred action for childhood arrivals, DACA, originally implemented on June 15, 2012, will be expanded to include adult arrivals who entered the United States on or before January 1, 2010. DACA age restrictions will be eliminated. You won't be too old to apply. And DACA benefits will be granted for 3 instead of 2 years. Another DACA consideration addresses educational and public safety criteria, which will remain unchanged, and this means that applicants will still need to have graduated high school or be enrolled in a high school or GED program at the time of application. Finally, the new criteria for existing grantees of DACA should go into effect within 90 days of the President's November 20th, 2014 announcement. It's been my observation that they've been put in place already in all the cases I've filed, but there may be different experiences throughout the country. Let's talk about enforcement priorities. That's an important issue, because these bar a grant of DAPA or DACA relief, and they include persons targeted as national security risks, a very general term that is more narrowly described through 3 priority groups. Priority 1 are persons suspected of terrorism or espionage, violent criminals and convicted felons, persons convicted of aggravated felonies, a broad group of mostly felony, but a few misdemeanor convictions as defined under the Immigration and Nationality Act, and gang members. Finally, recent border crossers, so people who came in the United States after January 1 of 2014 will not be able to apply for DAPA, even if they are the parent of a U.S. citizen. Priority 2 enforcement includes persons convicted of serious or multiple misdemeanors, which include 3 or more misdemeanors that are not minor traffic offenses or state or local offenses that criminalize unlawful immigration status. Then there's significant misdemeanors. These include domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking, driving under the influence of intoxicants. But you must take into account that domestic violence convictions are mitigated by any determination that the defendant was also a domestic violence victim. A misdemeanor for which the individual was sentenced to a time in custody of 90 days or more are also in priority 2 enforcement concerns. Persons who have significantly abused visa or visa waiver programs is an issue of concern. This is yet to be defined because there's no such language in the Immigration and Nationality Act. Guidance is yet to be provided for all of these provisions, however, and a mere admission admission overstay cannot foreseeably be included. Finally, there's priority 3 enforcement issues. Now, priority 3 enforcement issues include persons who failed to leave the United States after being issued a removal order after January 1, 2014, and persons who returned after removal from the United States after January 1, 2014. Exceptions available to persons subject to priority enforcement include persons who qualify for asylum or other forms of humanitarian relief, persons whom the ICE Field Office Director and the CBP Sector Chief or Director of Field Operations, in their judgment, decide are subject to compelling and exceptional factors that clearly indicate that this person is not a threat to national security, border security, or public safety, so as not to be an enforcement priority. In making such a judgment, DHS personnel should consider the following factors, and there are many. They should consider extenuating circumstances involving the offense or conviction, such as duress, self-defense, or other extenuating circumstances. The passage of an extended length of time since the offense or conviction, underlying the conviction was committed. The length of time of the individual in the United States, an individual's military service, or family or community ties to the United States, status as a victim, witness, or plaintiff in civil or criminal proceedings, and any other compelling humanitarian factors such as poor age, such as poor health, old age, pregnancy, exceptional youth or infancy, having a young child, or having a seriously ill relative, or being seriously ill oneself. These factors are not intended to be dispositive, nor is it a list that is intended to be exhaustive. Decisions should be based on the totality of the circumstances. You have to look at all the facts, or the government, should look at all the facts and make a determination whether or not people are outside the enforcement priorities because of these facts. Persons convicted under state law for their unlawful immigration status will not be targeted, even if such a conviction is a felony. However, persons with a federal felony conviction involving an immigration violation, such as entry after deportation, may be considered an enforcement priority. Relief is available to such persons in removal proceedings, and that's important to note. Persons who are eligible or appear to be eligible for either DACA or DAPA benefits will have their removal cases closed. Such persons will be allowed to live and work in the United States during the 3-year time increment. Special provisions will be implemented in immigration court to ensure that representatives are accredited and competent, so unauthorized practice of law will be shielded against. Now, let's talk about the special benefits that will be extended to pending immigration applicants for high skill employment classifications. And these are as follows. Portable work authorization will be granted to high-skilled workers and their spouses awaiting green cards, so as to allow them to work not only for their sponsoring employer, but for any other employer offering similar employment to that offered by their initial petitioning employer. The spouses of H-1B high-skilled non-immigrants, also known as specialty occupation workers, or in common language, professionals, will be granted unrestricted employment authorization, where their H-1B spouse has been granted an employment-based immigrant petition. Enhanced immigration options will be made available to foreign investors and entrepreneurs, allowing streamlined procedures for such immigrants whose income is high enough to exempt them from receiving tax credits that are available to U.S. citizens under the Affordable Care Act. Certain unlawfully present persons who entered the United States without inspection, who have since created employment opportunities for other American workers through their entrepreneurial activity, will be able to be paroled in place to avail of immigration opportunities. Streamlined employment-based immigration procedures will be made available for foreign workers and international corporate transferees while continuing to protect American workers. This is the most important one to my heart. Family separation will be reduced for persons waiting to obtain permanent resident status. Also, persons in lawful status will be ensured by new regulations to have access to travel to their home country through the expanded use of parole. Additionally, visa processing will be streamlined and modernized by eliminating redundancy and emphasizing efficiency. Also, public education will streamline pathways to citizenship. Now recall past discussions on provisional waivers, removing the need for lengthy waiting periods outside the United States during which time unlawful presence waivers are being adjudicated by the United States government. Recall that these waivers are now adjudicated in the United States before the visa applicant leaves the country and comes back in. These provisional waivers will be expanded to all eligible immigrants to waive unlawful presence in the United States beyond just immediate family members of U.S. citizens, as the program currently allows and is so restricted. Criteria reflected in case law contributing to a finding of extreme hardship will be codified more carefully to include, but not be limited to, family ties to the United States in comparison to lack of family ties in the country of removal. Additionally, conditions of the economy and society in the country of removal, presence of war or other forms of chaos, the age of the U.S. citizen or permanent resident, spouse, or parent, the length of residence in the United States, relevant medical and mental health conditions, financial hardships, and educational hardships. Now this one is a clincher. The Secretary of Homeland Security has been directed by the United States Citizenship and Immigration Service to consider certain criteria by which a presumption of extreme hardship may be determined to exist. Finally, the President discussed military service as a pathway to permanent resident status. Enlisted service will be made available to spouses and children of U.S. citizens. The President will also be calling on Congress, that is, the same Congress that has refused common sense, comprehensive reform so far, to implement the following enforcement measures. The Congress will hire 20,000 additional Border Patrol agents, doubling the number presently on our borders right now. There will be a crackdown on companies who hire undocumented workers, and the President is calling for Congress to create an earned path to residence and citizenship for undocumented immigrants who pay a fine, pay taxes, pass background checks, learn English, and go to the back of the line behind those persons currently waiting to immigrate, but who can't due to exhausted quotas and visa backlogs. Shifting staff priorities are also being directed by the President. There'll be a prioritization to hire more immigration judges and court staff and focus these staff towards recent border arrivals. There'll be a requirement for quick adjudication of priority cases and termination of non-priority cases in the exercise of prosecutorial discretion. Also, the Department of Labor will expand and strengthen immigration options for victims of crimes by means of U visas, and victims of unlawful human trafficking by means of T visas, for all persons who cooperate, all persons who are victims and who cooperate with government investigations seeking to arrest and prosecute the perpetrators. Victims will be encouraged to avail themselves towards the protection of their labor and employment rights, and to be protected against retaliation. The secure, and this is another important issue to many of us, the Secure Communities program will be replaced, it'll be gotten rid of, by a new program called Priority Enforcement Program, which I've basically described. Secure Communities has been long alleged to have separated families by arresting and deporting parents of U.S. citizens, many of whom were detected after being arrested for the lowest level offenses, such as traffic violations. The Priority Enforcement Program will remove convicted criminals, deporting those serving time as soon as possible to avoid the continued cost to the American taxpayer of incarcerating somebody who's going to be deported anyway. Detainers will be discontinued, eliminating the request that ICE has issued to local jails and state and federal prisons to hold persons for a voluntary period of 48 hours or less for ICE to take custody after serving their sentences. Instead of detainers, ICE will issue a request for notification by a law enforcement entity when a convicted criminal will be released in the near future. This will allow ICE to prioritize which persons to place under their custody and which to decline commission to detention. Agency personnel, organization, classification, and pay rate will also be restructured. This restructuring will include the creation of a South Border or Southern Border Command and Control operation within 90 days of the President's order, so as to coordinate and better use border resources, coordinate U.S. Customs and Border Protection, CBP, the U.S. Immigration and Customs Enforcement, ICE, and the U.S. Coast Guard. ICE job duties shall be realigned and job classification changed with revised personnel pay structure to reflect shifting workloads, particularly within enforcement and removal operations, otherwise known as ERO. I'm going to end this discussion tonight by noting one of the favorable provisions of the President's most recent executive order, and it's this. Secretary of Homeland Security Jay Johnson has further explained in one of his memos that the parole power will be now reinterpreted to be treated consistent with very important and recent administrative precedent, decisions by the Board of Immigration Appeals that guide us, which hold that leaving the country on advance parole with ties to the United States and expectations that one will be able to immigrate to the United States, that such a departure, while physical, is not a departure at all. Let me explain to you why that's so important. The need to consular process necessarily arises because one can't adjust status. And one can't adjust status if they have not been admitted or paroled. Now, what does parole really mean? Let me first explain what admission is. Admission is with a visa, with status. Take the visa, come to the United States, and you're admitted in status, and that status is either immigrant status, defined many ways, or non-immigrant status, also defined many ways. Congress creates visa classifications and status, not the president. But the executive, for many, many years, has paroled people into the United States who are not qualified or have not been predetermined to qualify for immigrant or non-immigrant status. And that's what parole is. Okay, you're not an immigrant, you're not a non-immigrant, well, come on in, you're paroled. It's a miscellaneous entry. But it's not yet an admission. Ultimately, when you immigrate, or you come in as a non-immigrant, of which there are many varieties, some are very short term and some are very lengthy, you're admitted as an immigrant or a non-immigrant. Everybody else is paroled. So by being paroled, you can now adjust status. Now, we've discussed in other sessions together that when you leave the country after being unlawfully present, then you're 10 years inadmissible unless you can show that you qualify for a waiver, that your U.S. citizen or permanent resident spouse or parent will suffer extreme hardship with many, many criteria, and we've discussed a little bit about the criteria necessary to show extreme hardship in order to qualify for a waiver of unlawful presence. But now, as the president so directs, by being paroled, you will have never legally left. So you might have physically gone back to your nation of origin and come back to the United States to be paroled, but legally, you never left. And as you never left, you don't need a waiver, which reduces significant expense and effort to pardon unlawful presence. So with that in mind, there will be so many individuals who can immigrate with less stress than they have been constrained to do for the past 2 decades. And that makes so many of us so happy.